Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument in two cases this morning. First is 21507, Hidalgo County Water Improvement District versus Hidalgo County Irrigation District, both from Hidalgo County, and the 13th Court of Appeals District. And then 21843, American National Insurance versus Arce from Hardeman County and the 7th Court of Appeals District. The court has allotted 20 minutes per side in each of the arguments and will conclude them this morning. The arguments are being webcast live and will be available in the court's archives later today. We're ready for argument in 21507.
May it please the court, Ms. Coy will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court. To build a water pipe for the public, my client sought to condemn a 10-foot easement under the land of the Irrigation District, just as the legislature has authorized us to do. The question before this court is whether for the first time in your history, you should recognize a common law immunity barrier to that permitted taking, handing the first use a trump card. You should not for 3 reasons. First, recognizing common law immunity here would nullify the legislative delegation of important government power. Second, history. Throughout the development of Texas, this court has routinely addressed instances like this, and it has done so under the paramount public purpose doctrine, which directly resolves the issues here. You should be reluctant to depart from that precedent. Third, it is unsurprising that immunity was not a bar throughout history because none of the reasons for recognizing immunity apply here. Condemnation does not threaten the public fisc with any cost or consequences of improvident government action. There's no improvident action alleged here.
Let me ask you, there's been a lot of talk in this case about these two entities being co-equal governmental units. And so my question is, would it matter if, say, for example, the canal were owned by the state rather than by the irrigation district? Is that of any relevance?
No, Your Honor, to the extent the condemnation is authorized in the first place. So
Sure.
State
assuming there's condemnation authority, right?
No, Your Honor. If we have the power to condemn, if the legislature has delegated the power to condemn the land at issue, then the question is, can this authorized condemnation proceed, or is the court going to use immunity as a sword to stop the authorized condemnation rather than as in its normal course as a shield to protect the government against an allegation of government wrongdoing and protect the public fisc? Finally, I'll note that even if the court disagrees with me and concludes that there is immunity, the court should find waiver here under Encore by the specific and restricted grant of power here to only specified entities for enumerated purposes subject to restrictions to take any land subject to restrictions. I'd like to start with condemnation power. It is, of course, this court's duty to determine the boundaries of immunity, but you shouldn't do so in a vacuum. Here, the intersection between immunity and condemnation is only in theory possible when the legislature has already delegated the ability to take public land. If only private land were at issue, then immunity would be irrelevant. So the question here is when the legislature has said, you entity can take public land for the public benefit as is a right of government that predates the Constitution. And when the legislature has enacted an entire scheme around that, accounting for that taking, with the common law backdrop in mind, should this court come in and recognize a new common law immunity that halts that taking in its tracks? And the answer is No. This is critical for Texas. If you look outside, what you see is the shared use of public land for the public benefit. Texas would be unrecognizable if immunity had been a bar throughout history. Fortunately, however, it wasn't. This court from the early 1900s all the way through Canyon in 2008 addressed situations just like this, and it did so under the paramount public purpose doctrine. That common law doctrine that you created in the 1800s addresses the precise situation here of when two entities have both been granted the authority to use the same public land for the public, and the second has been told, your use is so valuable that you can take public land to accomplish that.
Is there any discussion of immunity at all in those cases, or is your argument premised solely on the absence of any discussion of immunity?
Yes, Your Honor, those cases do not discuss immunity. And I'm not saying that those cases mean that you are barred from applying immunity, but what those cases tell you is that throughout the development of Texas, immunity wasn't a factor. Number one, you created a common law doctrine that directly addresses this. That this doctrine directly addresses when two entities both have the authority to use the same land. How do you balance those competing policy interests? Immunity says nothing about that. Immunity just comes in as a trump card. And beyond that, the fact that immunity wasn't discussed, even though the court has a duty to determine its own jurisdiction, even though immunity is jurisdictional, is telling. And that's because there are none of the reasons for creating immunity apply here.
Isn't what happened is several years ago, I think it was around 2010 or something like that, we decided a case where we assumed that there was immunity, and then we went into waiver, and that's kind of the direction that these cases have gone without us really dealing with the issue of whether or not we should recognize immunity in the first instance. I think that's what happened.
Exactly, Your Honor. So throughout history, Canyon is a great example. Canyon is on all fours with this case. In the Canyon case from 2008, a water district just like my client sought to put a pipeline in a lake that was used for recreational purposes. And the court didn't look at immunity at all there. Yes, to your point, immunity wasn't raised, but the court said, we're going to look at this paramount public purpose doctrine, and the first inquiry there is, can both uses coexist? Because the legislature has enabled both uses. The public good is supported by having both uses. And there, the court enabled both uses to coexist because they could. And in Encore, the court raised the prospect of immunity, but this court has never held that immunity applies here. And when you look at the reasons for why you would apply immunity, it makes perfect sense why you've never held that it applies. Immunity arose out of the concept that the king can do no wrong. And in modern justification, the primary purpose for immunity is to protect the public fisc from the cost and consequences of improvident government action. And this, just like your Conroe case, has none of that. I'll start with, this is not an action against the government at all. This alleges no improvident government action. This seeks no liability. This is instead an action for permitted condemnation. And again, condemnation, the public taking of land for the public benefit, is a governmental power that predates the Constitution. It's an accepted part of our society.
Having to do with that aspect of your argument, how relevant do you think, or what do you think we should look at SCOTUS's decision in Penn East when they really looked at this as an in rem situation rather than in personam, because we're talking about land instead of a person who's been allegedly harmed?
Just as Conroe explained, the fact that this action is in rem is an important reason why immunity doesn't apply. We're not arguing that it's dispositive and that no in rem actions could ever have immunity at all, but the fact that it's
But
in
I'm
rem...
asking, what do you think the relevance of that SCOTUS opinion would be on us, considering we're talking about state sovereign immunity as opposed to federal sovereign
Right.
immunity?
Well, Penn East is different in the sense that you're dealing with states that were sovereign who then joined the union. And you're dealing with the 11th Amendment and all sorts of concerns that don't play in at all here. When here we're talking about whether these governmental entities share in immunity that this court would would recognize under the common law.
So do you believe that, it's not binding on us, but do you believe that that would be some authority for us to rely on? Is it analogous enough, or are there certain similarities here?
Whether a state
The issue being basically whether or not, you know, whether or not a state who is, or an entity of a state that is trying to do something for the public good, and whether that can be blocked because of sovereign immunity by either whoever, you know, whoever it is.
No, in the sense that, as I said, these states were, this governmental entity was never its own sovereign unit. Right. It's completely different circumstances. There's not an 11th Amendment here analog that says that controls there. But even in that instance, what the majority of the Supreme Court held is that by joining the Union, any assertion of sovereign immunity here that would have existed was gone. And so to the extent that you would apply a similar reasoning here, then the same principle would apply. The key takeaway from Penn East,
Could a private condemnor, like a pipeline company, take the government's land?
to the extent it is authorized to do so, yes, because to the extent that the core question here is there an authorized public taking? We have recognized as a part of our society that we're going to accept eminent domain. And your question goes to whether eminent domain is good or not. But to the extent we've accepted the proposition that eminent domain can happen, when the legislature has delegated this power of eminent domain, then immunity should not be used as a sword to come stop the use of that power. And
That's
I'll take you
what
back
happened
to
in Imperial Irrigation, right? That was a private entity taking state land. In Imperial Irrigation in 1911, taking public school lands.
Yes, Your Honor, and what this court's history has shown is in fact the opposite of where Respondent is asking you to go now. Take, for instance, the Jane case. In Jane, the power of condemnation was given only for private land to an irrigation district, a lot like our case. This is from 1911 as well. And in that case, the court looked at the purpose of the irrigation district. It was trying to build a reservoir as permitted. And the court said, even though the grant here includes only private land, we're going to say by necessary implication that has to include public land, because otherwise you can never accomplish your goals as the government. Here, this would be doing the opposite. This would be taking a clear legislative delegation that you can take public land, and in fact, you can take any land subject to clear restrictions to accomplish this goal.
Have there been any of the cases that did not include that kind of authorization that would, I take it, qualify as a waiver in your alternative theory?
No, Your Honor, because
So in other words, if all the cases have proceeded without discussing immunity, that's one of it. We've gone all these years without really talking about immunity. But if in all of those cases we've also had language that would constitute a sufficient waiver of immunity, isn't that an equally good outcome for your client?
perhaps, Your Honor, yes, in the sense, and this is what I come back to, that condemnation and immunity could only ever intersect when the legislature's already spoken. So you could view it as a waiver. In the first instance, before you would ever get to a waiver, you have to address, as this court has explained, whether immunity applies in the first place. And to me, this is a reason that immunity doesn't apply in the first place.
What do we do with Lane? How should we read Lane?
Absolutely, Your Honor. Lane is categorically different for two core reasons. Number one, Lane directly falls under the reasons why you create immunity. The primary reason for immunity is to protect the government and the public fisc from the consequences and costs of improvident government action. In Lane, the allegation is governmental wrongdoing, trespass to title, wrongfully claiming title. And so right there, applying immunity protects the public fisc and that governmental entity from the costs and consequences of its alleged improper action.
It seems like to me that we don't typically ask when any given suit against the government comes along whether allowing this suit or barring this suit by sovereign immunity would serve the purposes of sovereign immunity. Right? It's a rule of general applicability that requires the government's consent to be sued and then to be subject to a judgment from a court. And so I'm struggling with this notion that, well, that rule might not apply in cases where applying it doesn't serve the purposes, because then we'd be sort of back at square one every time we're asked to apply immunity, asking whether, well, in this case, does it really serve the purposes? And it seems like a clearer rule that requires consent from the government would be preferable, and that perhaps we have that in these cases.
Your Honor, that's not what this court has said. This court has not said as a blanket immunity always applies. Look at Conroe. Immunity doesn't apply to EDJA actions. Immunity doesn't apply to a Bill of Rights action. Immunity doesn't apply to inverse condemnation. Immunity doesn't apply to ultra-viruses. This court has routinely, throughout its history and in its modern jurisprudence, looked at a case-by-case basis saying, in this instance, do the purposes of immunity get served here? And here, none of the core purposes get served, and it would be a direct infringement on separation of powers vis-a-vis the legislature and vis-a-vis this second governmental unit, my client, who has been given the power to condemn public land to carry out its required purposes.
Your point about the public fisc not being affected makes sense when you're talking about an exchange of assets at fair market value, which a condemnation proceeding is supposed to reflect. So the overall public fisc isn't affected because it's an exchange of assets. But I think the irrigation district says, however, if something goes wrong with the operation of your pipeline and our irrigation district assets are damaged by that, your client can claim immunity. So you're shifting the risk of future impairment damage to their use to them. And so their overall risk is heightened. Should we look at it as the individual governmental body, the overall public fisc, or does it even matter that there's a shifting of risk here?
May I answer the question,
Yes,
Your Honor?
you may.
First of all, you do look at it as the overall governmental body, but any costs or consequences that they're alleging here, first, are not costs or consequences of improvident government action. They're costs and consequences of permitted condemnation, the permitted taking of public land for the public benefit. So those are not the concerns of immunity. Second, the legislature has already accounted for all of this. The legislature has enacted a comprehensive scheme that says if we take possession and we're not allowed to, we have to pay them. We have to compensate them for the taking. Third, if we go outside of that bounds and we commit an additional taking that's not permitted, they have an inverse condemnation claim against us. And we don't have immunity from that. If we commit a separate tort, that's a whole separate doctrine. Then they can bring a tort claim against us. None of that falls into the permitted condemnation. And I'll bring you back to the core point to sum up that none of what we're talking about here are costs or consequences of improvident government action, which is what immunity shields. Instead, this is a permitted, historically proper, authorized use of the condemnation power, the taking of public land for the public benefit. Thank you, Your Honor.
Any other questions? Thank you, Ms. Coy. We'll hear from the respondent.
May it please the court, Mr. Vail will present argument for the respondent.
May it please the court, good morning. The court should affirm the judgments below in this case that my client is immune to this lawsuit. In doing so, the court should recognize that governmental immunity applies to eminent domain suits and that section 49.222 of the Texas Water Code does not clearly and unambiguously waive my client's immunity.
Are there any clear and unambiguous waivers that would allow this kind of suit?
Yes, Your Honor, this court's found one in Encore.
As between public entities in this sort of a situation, I mean, are there waivers out there that would show us that the legislature does this and thinks this is how it works and waives it for some people but not others?
Are you asking if there's like an explicit waiver? Is that what you mean, like instead of an implicit one like in Encore? I'm not aware of one from the legislature.
What's your authority that its sovereign immunity applies in the first instance?
Our authority is based on the policy implication, so the courts role in determining whether immunity applies is based on whether the concerns of immunity or the policies of immunity are
So
implicated.
you're just arguing what we look at, but you're not citing a case.
Your Honor, this court has never decided one way or the other whether immunity applies. That's correct. So the court has been.
So Lane doesn't help you here?
Yeah, Lane does help us on this. Yes, Your Honor. So yes, our authority. Okay, you're correct. Lane, I'm sorry, I cut you off.
Go ahead. I want to know if you agree with your opposing
No,
counsel.
no.
that
So
Lane
our
is distinguishable.
So there's no case, to be clear, there's no case that holds that immunity in Texas from this court. There are courts of appeals that have held that immunity applies, but the Texas Supreme Court has not. The Texas Supreme Court has held that a suit for land, which is the Lane, State versus Lane case, and Pareto and Sawyer Trust and others have said that if a plaintiff files a suit for land, or a substance suit for land, that suit is subject to immunity. This court's also, though, held not just to protect.
Wasn't that in the context of title?
That was a case seeking title from the government, and the difference between.
What do we do with Imperial Irrigation and Humble Pipeline and the cases that, I mean, immunity is not a new doctrine, right? I mean, it's a very old doctrine, so you would have thought that if it was a problem, we would have raised it in 1911 or 1928.
I think that the reason that we're here today is mostly because of the development of the immunity doctrine more recently than that, and the Encore case, and this issue of if immunity applies, then the clear and unambiguous standard, to the extent there was any assumption about whether the legislative authority to take public land itself would dispose of immunity concerns, that assumption, I think, is in question as a result of Encore and Took versus City of Mejia and that development of authority.
But that's all about waiver.
That's about waiver, yes, Your Honor, you're correct. So the question is, to the extent, if there was never a discussion in those older cases, and part of that's because the court does not have an affirmative duty to investigate immunity as part.
Are there any cases that talk about whether the standards that we demand of waiver having to be expressed about the government also apply to grants of condemnation authority?
The court, aside from discussing in Encore, when the court assumed for the sake of discussion that immunity applied, the court discussed saying under this case, in Encore the court said that the mere grant, a general grant of authority to take public land in itself might be construed as a general power that would require an additional waiver. And so in that case, the court said that it was very specific. And that the statute at issue, which was a utility code provision, and I encourage the court when looking at how to apply Encore, the language in that case was that the statute was very specific. It was certain land in certain circumstances, and the statute provided specific restricted rights.
Well, the legislature was pretty specific here, too. They said, they carved out and said there are certain lands you cannot take, right, if it's another public entity. Doesn't the special districts code get into the details of this?
Not for this provision.
Right,
not
but
for
it
these
shows
entities.
that they're thinking about if they want to limit the grant of condemnation authority, they certainly do. In some cases, they say, but you can't take it from this sort of public entity.
They have for other districts.
Right, and would that all be just worthless, basically, under your view, because they wouldn't be able to do it anyway? So why did the legislature go to the trouble of saying, but you can't take this kind of public land?
I don't think it would be worthless, Your Honor, under the Took versus Mejia approach of analyzing statutes on a case-by-case basis.
But you wouldn't need to say you can't take this type of land if they can't take it anyway.
It would if you construe that to be a waiver.
Oh, it's a waiver to say you can't do it?
Well, I mean, it could be under the Encore standard requiring very restricted rights, right? Encore is looking for restrictions on power. That's what the court's looking for and concerns. I think our argument is that Encore is looking for limitations on power so that the court doesn't have to find an across-the-board waiver of every governmental entity in Texas based on a generally described power.
What would happen if the water district had just put their pipe through without asking you?
In that situation, we could potentially sue for inverse condemnation or an injunction to try to stop the trespass.
And there would be a waiver for that, right?
There would be a waiver. The condemnor's immunity would be
So
waived.
if you win here, all these cases are just going to be litigated that way, right?
I wouldn't assume that, no.
Why not?
I mean, I don't know if it's fair to assume that a government entity is just going to bulldoze another government entity's land.
Well, not at all. We should assume they're acting in good faith and reading the scope of their power according to what the legislature told them their condemnation authority was.
I think, no, I'm saying, Not saying it would never happen. I'm saying with the risk of that happening, I'm not sure that's their only remedy either. I mean, they could come to another agreement with an entity besides the one that they proposed to try to solve the problem, rather than doing inverse condemnation. And I think that's a factor that the legislature is better suited to weigh the how much of a risk that really is.
But we decide the scope of immunity.
You do. And the courts also, though, in the last 20 years or so, especially, and there's the interesting discussion in the State versus City of Galveston case about how does the court view that role, and how is that the thin line between abdicating that role and also keeping account of that this is that legislative question should go to the legislature. That's a better forum to judge what kind of risks are there really if the court does, rather than just a broad categorical exemption for a cause of action or construing the mere power to take public land. Rather than doing that, checking to make sure that the legislature actually wants these parties to be hauled into court on a case-by-case basis, and that prevents the court from overstepping into something that the legislature is better suited to weigh.
And here they've given that authority with the scope of the power of eminent domain.
Assuming that any land, we have our argument, but for the sake of this argument, that any land includes public land, even if that clearly and unambiguously includes public land, that grant is so broad. It's so broad, and the only restriction on it in this statute is the very generally described public uses of water purposes, flood, sewage, or drainage, or any other project that the district is working on. That kind of broad language, that's why the on-court decision is written in the way that it was, because of this concern and because of the way that immunity developed over time with the clear and unambiguous standard and the legislature demanding that standard itself.
If the water district had been a city,
yeah,
would this require its approval?
If you're talking about condemnor.
Right, is there an exception to the limitation of this is there a limitation on this broad power in the water code that would say if it was a city?
If we were a city.
If the taking was against a city?
I'm not aware. There are certainly in the local government code for some things that the cities have protections for controlling their own, I'm aware that they have control over a lot of things within the city limits, right? Especially roads. I don't know how that works with the water.
There's limitations on condemnation power by water districts within city limits.
Okay. Yeah,
and so would that be the sort of limitation we would look for to say that there is a waiver? Because otherwise you wouldn't need the limitation.
I don't know if I agree that by itself would be enough, that kind of limitation would be enough, but certainly on-court is looking for limitations. I think that I think the question in this case is how do we distinguish cases where on-court warns about a general provision granting the power to take public authority, and how does that differ from any other statute, any condemnation statute? It can't be enough that the statute grants just discusses the essential elements of condemnation if we're going to say that immunity applies in condemnation.
There have to be hundreds of these districts around the state, and thousands of county roads and public easements that would have to be crossed to do various things. And it seems to me that if the default rule is that any public entity that's got an easement or some land within the zone that you want to work on, if the default rule is that they can veto it, I have a hard time imagining that we wouldn't have seen these cases before. It sure seems to me like the world is operating such that the default rule is that is that this power exists and that they can do it, and that most people are working it out, unlike you all. But that default rule is extremely important. And if the default rule were that any little entity can veto any other entity's project if it crosses an easement, it just seems to me like there'd be a lot less development, and we would have seen a lot more of these cases. And I'm just afraid that if we were to rule for you and make that the rule, that we'd be interfering a great deal with development all over the state.
Again, I think that this comes back to the issue of if there was if the court is seeing these cases now, I think because of the development of the immunity doctrine, right? Because of the development of this concern that if the assumption was that the legislative authority to take public land was sufficient, or that this necessary implication doctrine was how we're going to construe this, that concern starts becoming greater as you start realizing that the clear and unambiguous standard requires a different analysis of these statutes and questions that assumption. I think that's why these are coming up now versus then. But the court never expressly addressed it. I don't know if that means the court wasn't in the court's mind, but the court never expressly address that.
I mean, those cases are about whether the government has consented, whether the legislature has consented to suits like this against, this
Right.
kind of a government entity. And that core question is sort of both the immunity question and the merits question in these sorts of cases. But it's the same basic question. So the fact that they weren't using the word immunity in 1911 to talk about that question doesn't seem particularly remarkable to me. It's a very similar question, whether you frame it as immunity or not.
I think that's true, except that the clear and unambiguous standard that's developed since some of those early cases that applies to checking for immunity is not the same standard the court was applying then. So if there was concerns about immunity, part of this is because the legislature mandated the clear and unambiguous standard in this early part of this century, and the development of, revisiting, 35 plus years of case law in the Took versus Mejia case.
If something has been assumed to be clear enough to authorize the suit for all these years, ought we to be hesitant to say, well, that's not clear and unambiguous enough anymore, if people have been proceeding for over 100 years as if it is?
I think that, but the legislature did require the clear and unambiguous standard since those 100 years. And also, part of the Took versus Mejia was overturning 35 years of interpretation of the sue and be sued clauses. I agree with you that a rule of stare decisis is that the court has to be more careful when it's talking about statutory construction. But part of this is that the legislature itself has required a closer look at its own statutes. That's part of, I think, what's going on in this case.
Legislature has also changed the rules for conferring eminent domain authority more recently, but my understanding is that prior grants are grandfathered into the old standards. So should we take that into account as well?
I'm sorry, I want to make sure I understand the question.
There's a separate statutory scheme that has to do with grants of eminent domain authority.
Right.
And my general recollection from other cases is that there was a change in the law that says now those grants have to be more specific in certain ways, and but that old grants didn't have to comply with this new standard. And there are certain hoops you have to jump through and requirements you have to meet. And so obviously the legislature is paying attention to this issue, but they've said, well, but the old grants we're going to allow to continue. So should we take that into account?
I'm not sure that I'm familiar with what you're talking about, but I think to some extent the court has to refer to what, keep in mind what the legislature's been thinking of this, but ultimately it does come back to the question of whether immunity applies under the principles of immunity and this court's role of determining whether immunity applies. So, yes, there is some question. There is obviously a question in this case about the historical approach to this issue and why the court should raise this now. I understand that that's an issue in this case, but I would say still that the legislature understands, and I think part of the Encore decision too is in part warning the public and the legislature, like, hey, if immunity is going to apply here, there may be some statutes that aren't going to pass muster. And I think the court shouldn't avoid immunity here because it's concerned that certain statutes aren't going to pass that test. I think the question is whether the court is going to reserve that role of saying just what the law is rather than whether immunity makes sense or whether waiver makes sense, whether waiver would make sense for these projects. I think that's what it comes down to. And also keeping in mind that though there are numerous eminent domain statutes out there, I don't know that it's necessarily, I mean, there are ways for the legislature to solve this fairly easily too. The legislature could, if it really disagrees with the idea of immunity, it could enact a single statute saying, in the government code or wherever, saying that all eminent domain suits where the taking of public land is explicitly authorized, that there's a waiver. But as the legislation stands today, the court is stuck kind of in this position of if immunity applies, yes, the court's going to have to do this statute by statute approach, and if the legislature chooses to do that, that should be the way this works.
So isn't it easier just to start at the very beginning and say that sovereign immunity just doesn't apply, so that we can give the government the ability, if they can prove that there's a rational need for a public whatever.
I'm sorry, go ahead.
Isn't that another way to approach it?
It would be a way to get to that result, for sure, an easier way to get to that result, but I don't think that's assuming that the legislature agrees with this, right? I would agree with the court on that policy judgment.
I don't think so. I mean, it's up to the courts to determine whether sovereign immunity applies, and if it doesn't, you never get to the waiver part of it.
That's correct. But I think that the court's going to have to grapple with the problem that eminent domain seeks to sue an innocent government entity to take that government entity's land without that government entity's consent.
But the legislature seems to be assuming that you can do that already. Otherwise, why would you have Special Districts Code 3954-104, which says that certain water authorities have the power of condemnation under the Water Code, except that the district may not acquire by condemnation a property interest or facility owned or controlled by a public entity. So the legislature is already taking into account in granting condemnation authority whether they want it to apply to public entities, which they wouldn't have to do if they thought immunity applied.
I think, but you could also say that the legislature is putting that kind of restriction in there, and that's a clear indication of legislative intent that the legislature intended to waive that immunity.
Well, either that, or you could say it's a clear indication of a limit on condemnation authority, and it doesn't have anything to do with waiver because there's nothing to waive.
Well, I mean, but yes, I understand what you're saying, Your Honor. I do, but I think that at the end of the day, though, the legislature still does not make the call at the beginning of whether immunity applies. The court does. The court has to look at the purposes that immunity serves.
Are there other examples where you have a statute authorizing somebody to sue the government, but you don't have a corresponding statute, waiving the government's immunity to that suit, and the result is that you can't bring the suit?
Well, I mean, a trespass tri-title action, I mean, it depends. We would have to look at whether, right, a trespass tri-title action is a statutory action. That's at the issue at Lane. There's still immunity in that role, right? And there are,
well, go ahead.
But, I mean, I don't know. So the way the court has analyzed this, right, is that if the mere fact that a statute envisions a governmental immunity's involvement in a lawsuit does not necessarily mean that statute has clearly and unambiguously waived that governmental entity's immunity. So the mere fact that the government could be a defendant to a statutory cause of action, DTPA, trespass tri-title, that doesn't necessarily mean that there is immunity. I think the question here, though, is if assuming the statute...
Assume any land means public land.
Correct. Assume any land means public land. And then the question... I don't have an example for you of a situation where that would happen. I think the way the court has applied, like whether does the government have to be a necessary party under like the Wichita Falls, Hamill kind of factor test when talking about waiver, has been mostly about whether is the government like explicitly a necessary party, or, and I think that's kind of the analysis. But I don't have an example for you. I think my time is up.
Any other questions? Thank you, Mr. Vail. Ms. Goy, you have 5 minutes.
Respondent just said that this would be a suit against the government, and I want to just emphasize this is not a suit against the government. This is a permitted condemnation proceeding, the permitted legislatively desired method by which a governmental entity takes public land for the public benefit. Second, he focused on Encore and said Encore required specific and restricted language. Whether you're viewing this as a waiver or for no immunity, which is what we urge you to do, this falls directly under that. Let's look briefly at the provision here. This grants only certain entities, water districts, not port authorities, not navigation districts, the authority to condemn land for enumerated purposes as necessary for water, sewer, storm drainage, flood drainage, and control, subject to restrictions, not for water rights, the power to take any land subject to restrictions, not cemetery land, unless there are one of three very specific reasons why you're proceeding. This is a clear, specific, and restricted delegation of power. And coming back to the no immunity point, for this court to say that there's immunity here, you are directly creating separation of powers problems and interfering, using immunity as a sword, as it's not traditionally used, with the prerogative of the legislature, which is Justice Bland wrote in the Rita's case, that you recognize sovereign immunity.
If the authorization to sue is itself the waiver, then what difference does it make whether there's immunity, really? I mean, that's not interfering with anything. It's just kind of a doctrinal hoop that you're jumping through to get to the exact same place.
Perhaps, but it's this court's duty to determine the boundaries of immunity, and if you view it that way, you require in every instance a case-by-case analysis of exactly what the statute says and whether it qualifies as clear and unambiguous, which results in the current mess where you see the strong amicus presence. People want to know if there's immunity here or not, and none of the reasons for creating immunity here apply. And I'd like to take you briefly to Justice Busby's point about inverse condemnation. Were this court to hold that there's immunity here, you're creating a real mess, not only as the amicus show, but because the power of eminent domain still exists. What you're nullifying is the legislature's preferred method for how this should proceed and the entire scheme they've set up. And this court, Ritchie v. Rupert and otherwise, has always been reticent to overturn an entire scheme created by the legislature. Here, you would be directly nullifying that and leaving three situations. Either in an instance like this, where you have, every time you have a really long linear project, you're gonna stop that project if there's immunity, unless there's a waiver, or unless there's agreement and you don't need the condemnation power anyways. Or you have something like the In re Lazy Tarrant County amicus situation, where you're, quote, fortunate in that you have the ability to still proceed, but you take a lot more public land at much greater cost to the public good to accomplish your goal. Or you're left with a situation where the only way for my client to exercise its inherent government power is through essentially acting rogue, acting in a way that the legislature has said you should not proceed that way, and just going and taking the land and subjecting itself to an inverse condemnation suit, as this court has said routinely, for instance in Holland, can happen. That is not desirable. We also talked about the default rule. Justice Blacklock brought that up. The default rule is critical here, and the default rule is really important. The paramount public purpose doctrine and the legislature's enactment have evolved symbiotically. The legislature acts with knowledge of the common law, and the paramount public purpose directly addresses this situation where there are permitted multiple public uses of the same public land. We're talking about public land. This is public land held for the public use and the public benefit. You've already have a doctrine in the common law that directly addresses that. Immunity doesn't address this at all. It doesn't address in any way the competing public uses. It just gives a trump card to the first, even if the two could coexist, and that's better for the public, or even if the second is better for the public. The paramount public purpose doctrine says if they can coexist, they will. If the second will destroy the first, then it can only proceed if it's paramount for the public and accomplishable in no other way. This directly effectuates the legislative will. It balances competing public uses of public land, and it maximizes public benefit from public land, which is precisely what condemnation is. Condemnation is enabling the taking of land for the public benefit. Immunity says nothing at all about that. It doesn't in any way address two permitted public uses and the competing benefits for the public. It just comes in as a trump card saying, first in time use, you always win. For all of these reasons, immunity doesn't apply, and we urge you to reverse and remand for our condemnation proceeding to move forward.
Any other questions? Thank you, counsel. The case is submitted, and the court will take a brief recess.